Hello, ladies and gentlemen. Welcome to the Canada Truth Channel, where Canada, the illusion of freedom and system of control, is exposed. I have a very exciting video for you today. Let's call it Putting the Last Piece of the Puzzle Together Through Case Law. Oh, exciting, you say? Case law, you say? Yes, I do. Because within their system of control, within their legal system, through their court opinions and decisions, we will find the pieces of the puzzle in order to achieve truth, justice, and freedom, and do away with this Admiralty maritime law, banish it back to the sea where it belongs. So, studying case law is very, very important, especially which I will have to say, I do not encourage any of you to go out and challenge the system of control through the courts unless you have studied for years and have an absolute personal knowledge and understanding, have studied case law, and are prepared to defend yourself and answer correctly without getting yourself into more trouble, anything that they may throw at you. Because guaranteed, they're going to throw every possible thing you have imagined and can't imagine at you in order to prevent truth, justice, and freedom. Remember, you're fighting their system. It was created by them, for them, through law societies and governments. It was not created by the people, for the people, as a constitution should be, which I've shown in previous videos. Many people out there have a basic understanding of the deliberate deception, fraud, and tort or trespass through the mandatory birth registration and application for a birth certificate, which the government creates an artificial person with a name similar to ours, where the style has changed from both upper and lowercase letters to all capital letters. You'll find this on all your government correspondence or government identification. And at least the surname will be in all capital letters. We have shown previously on this channel that what that signifies, the style of the name change, not the spelling, the style, is called Capitis Diminutio Maxima, and it stems all the way back to Roman civil law. Whoops. Capitis Diminutio. Capitis Diminutio Maxima, the highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage when he became a slave. So, through the mandatory birth registration and application for the birth certificate, the naturally born man or woman with inherent rights and the duty to do no harm, a free human being, through deliberate deception and fraud and tort or trespass, and the mandatory birth registration and application for the birth certificate, the artificial person is created, taking the naturally born man or woman free into an artificially created, fictitious, legal person or corporation created by the government, for the government, with granted rights and inherent duties. A maxim of law: that which creates owns. We didn't create our birth certificate. We didn't change the status of our name. The government did. Now, a lot of people out there have also been studying the Constitution Act and the Charter of Rights and Freedoms, where right off the bat we see, whereas Canada is founded upon the principles that recognize the supremacy of God and the rule of law. Well, from what we have learned and shown through this channel, I would say this statement is fraudulent right off the bat. Whereas Canada is founded upon deliberate deception and fraud, and the color of law is what it should read. So many people out there have been studying and have come across Section 32, application of the Charter. This Charter applies to the Parliament and Government of Canada in respect to all matters within the authority of Parliament, including all matters relating to the Yukon Territory and the Northwest Territories, and to the legislature and government of each province in respect to all matters within the authority of the legislature of each province. People have been asking, okay, so this says the Charter only applies to the government. And then they cite Section 52, primacy of Constitution of Canada. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force or effect. All right, so the Constitution, including the Charter, is the supreme law of Canada, and all other laws, acts, statutes, regulations, codes, bylaws, rules of the court, rules of civil procedure, all fall under Section 52. And if they're inconsistent with the Constitution or the Charter, they're of no force or effect. All right. Now back to Section 32. Now this applies only to the government. It's the supreme law and all laws are under it. Then how do acts, statutes, regulations, codes, bylaws, rules of the court, rules of civil procedure, how do they make those apply to the men and women of Canada? Well, ladies and gentlemen, it starts with the birth certificate, the deliberate deception and fraud of the birth certificate. And we have to apply for it. And when you apply for something, it is presumed in law that you know exactly what you're applying for. Aha! They don't give us all of the information, but they presume that we know exactly what we're applying for. Now, when the artificial person comes of age to go to work, unbeknownst to the man or woman who has been led to believe, has been deceived into believing that the artificial person, the corporation created by the government through the mandatory birth registration and the application for a birth certificate, needs to go to work. We are also told it is mandatory for the people of Canada, the citizens of Canada, to apply for a social insurance number, a SIN number, which we do, which has our legal person status altered, artificial person or corporation name, not our name. Here's our name down here. This is how we men and women write our names. This is creation of the government. Capitis diminutio maxima. And we unknowingly sign and agree to their Acts Statutes, regulations, codes, bylaws, rules of the court, rules of civil procedure. When we do this, when we in fact apply, which we're told is mandatory, to get our social insurance number and use our social insurance number, we are acting as agents of the government and we are implementing government policies. For example, employment and immigration, Acts, statutes, regulations, so on and so forth. The Income Tax Act. When we get a driver's license, we're implementing the requirements of the Highway Traffic Act and all of the regulations involved with it. Our artificial person is acting as an agent of the government, which binds us to their laws, to their Acts, statutes, regulations, codes, bylaws, rules of the court, rules of civil procedure. Because, as we have also learned, Canada, the government of Canada, is a de facto government. The government is in fact a crown corporation, the Crown Corporation of Canada, or the Crown Service Corporation of Canada, if you prefer. And we are all employees of that corporation, unbeknownst to us. And the last piece of the puzzle is the social insurance number and our driver's license. Or a firearms license, a fishing license. We are implementing the laws of the government. And therefore, number one, our artificial person or corporation was created by the government. That which creates owns. We don't own the birth certificate. We've just been deceived into believing it's us. And being deceived into applying for it, which it is presumed that we know exactly what we're applying for. Same thing with the social insurance number. So through court decisions, we can figure out all of the pieces of the puzzle. Now, before I go any further, I would like to jump to the Interpretation Act, which, as we've learned, is the highest legal definition of a word in their laws, in their acts, statutes, regulations, codes, bylaws, acts of rules of the court, rules of civil procedure, criminal code. Person, or any word or expression descriptive of a person, includes a corporation. Well, most people would read that and use common usage understanding, common usage definition, and say, okay, corporations are included as men and women, which is basically true. Corporations have been given some of the rights of natural people, which we will see in case law and court opinions and decisions. And we know if we apply our maxim of law, expressio unius est exclusio alterius, the maxim of law, the rule of law, which says the explicit mention of one thing is the exclusion of another. A principle in statutory construction. When one or more things of a class are expressly mentioned, others of the same class are excluded. Moving along. Latin, that which is expressed is included, and that which is not is excluded. A rule of statutory interpretation that says if something is mentioned as being included, then anything that is not mentioned is by implication meant not to be included. So it is a rule of law in the construction of statutory laws, Acts, statutes, regulations, codes. And it is also a rule of statutory interpretation. So when you're reading Acts, statutes, regulations, codes, bylaws, you apply this rule. It's not new. It's very, very old. It stems all the way back to Roman civil law. Now, once again, we apply that to person in the Interpretation Act, and as well as the Criminal Code and many others. Person, or any word or expression descriptive of a person, includes a corporation. So it includes a corporation, therefore applying our maxim of law, our rule of statutory construction, and our rule of statutory interpretation, person can only mean a corporation. Okay, moving right along. That was a little more long-winded than I intended. I apologize. Let's get going. So, McKinney versus the University of Guelph. Many people out there have heard of the Dell case or the Big M Drug Mart case or maybe the Oaks case. There's many cases out there where legal opinions and legal decisions show us that the Constitution and Charter apply only to the government. All of the other laws in Canada apply only to the government. And we, men and women, have been tricked into acting as agents of the government. Our title is taxpayer. And therefore binding us to all of their laws. Just like any other corporation, when you join it, hopefully you've read the contract, understand the contract, agree to the conditions, know exactly what you're getting yourself into, and sign the contract. Otherwise, you don't sign it. Unfortunately, we're not given the same opportunity. So, in this particular case, I will start with for two reasons. The information, the legal opinions, and decisions in this case are very, very, very important to see and understand. It's the last piece of the puzzle, and it's in their own words, not mine. This case is regarding 8 professors and a librarian at the University of Guelph, who all, through their contract, agreed they would retire at age 65. So at age 65, they were all mandatorily retired, as per the conditions of their contract. Now, they sued the university on charter infringements and also on the Ontario Human Rights Code for violations. And it's kind of ironic, and I find it funny, that we're starting with this case to prove what we are saying, that we are government employees, because this case is regarding mandatory retirement at age 65. Now, we're not forced by the government to retire at age 65. However, we are given a pension at age 65. What entities provide a pension plan for their employees? Employers, corporations, and governments. Which are corporations? All right. Enough ranting. Let's get into the case law. So, as I said, 8 professors and 1 librarian. And this is an appeal that's gone all the way through the court system in Ontario, all the way to the Supreme Court of Canada. So the appellants, 8 professors and a librarian at the respondent universities, applied for declarations that the university's policies of mandatory retirement at age 65 violate Section 15 of the Charter of Rights and Freedoms. Per Dickinson, CJ at LaForest and Gauthier JJ, the wording of Section 32.1 of the Charter indicates that the Charter is confined to government action. It is essentially an instrument for checking the powers of government over the individual. The exclusion of private activity from the Charter protection was deliberate, which is, again, what they would have us believe. It was created to protect the people from the government. And private activity, private corporations don't fall under the Charter because there is tort law, common law for that. Only government need be constitutionally shackled to preserve the rights of individual. Private activity, while it might offend individual rights, can either be regulated by government or made subject to human rights commissions and other bodies to protect these rights. The court, in limiting the Charter's application to Parliament and the legislatures and the executive administrative branches of government in RW DSU versus Dolphin Delivery, which we will be also covering, relied not only on the general meaning of government, but also on the way in which the words were used in the Constitution Act 1867. And once again, our private activity is regulated by government through the creation of the artificial person, the deliberate deception and fraud committed by the government regarding birth registration and the certificate and social insurance number. We are unknowingly acting as artificial persons and government employees instead of acting like men and women who are the government employers. We have simply been brainwashed and conditioned into believing we work for the government, which in fact we do, which we're going to see through case law. The fact that an entity is a creature of statute and has been given the legal attributes of a natural person, a man or woman, is not sufficient to make its actions subject to the Charter. The Charter was not intended to cover activities of non-governmental entities created by government for legally facilitating private individuals to do things of their own choosing. So I believe they're referring to the artificial person created through the birth registration, as well as corporations which are incorporated through the government, private corporations, so they can do business. Now, legal eagles will argue that our artificial person was created so the natural person can do business in the artificial world. Oops. According to some court opinions and decisions, the artificial person or corporation alone does not make it part of government. Legal precedent has been set that entities must be acting as agents of the government or carrying out duties of government to be subject to the Charter, and therefore, by de facto, all other laws. By default, all other laws. I will review more case law as well in future videos, but everyone keep in mind that the Charter and this Constitution Act, that's deliberate deception and fraud. Again, if you don't know what I'm talking about, you can go back and watch previous videos where I show you through their Acts and Statutes and other things how it works. The fact that a university performs a public service and does not make it part of government. A public purpose test is simply inadequate. It is fraught with difficulty and uncertainty and is not mandated by Section 32. Although the Charter is not limited to entities discharging inherently governmental functions, more would have to be shown to make them subject to the Charter review on that they engaged in activities or provisions of services that are subject to the legislative jurisdiction or of either the federal or provincial governments. So, acting out government policies and procedures, we are forced into this jurisdiction through the birth registration and application of a birth certificate, which we are told is mandatory. Then we're forced to apply for the social insurance number, which really is our government employee ID number, which once again makes us agents of the government and therefore bound by their laws. The actions of universities do not fall within the ambit of the Charter because they do not form part of the government apparatus. The universities were not implementing government policies. This is another legal opinion that has been stated in this case. Men and women become part of the government apparatus through the birth registration and application for a birth certificate and the social insurance number, created by the government to implement their policies. People are implementing government policy through the Income Tax Act, GST, driver's license, firearms license, fishing license, marriage license. We are tricked into volunteering to enter their jurisdiction and become an employee of the government through deliberate deception and fraud. There's no other way to explain it. These policies were adopted in a formal manner. They're talking about the university policies. The fact that they were accepted by the employees should not alter their characterization as law. Our contracts with the government are in fact voluntary, as I've said. We apply for the birth certificate and we apply for a social insurance number, although we're told it's mandatory. This is deliberate deception and fraud and trespass or tort, as no contract can stand in law that's based on deliberate deception or fraud. Even though we're expected to know exactly what we're applying for. And here they state core functions of a university are non-governmental and therefore not directly subjected to the charter. More opinions that have been stated throughout all levels of the court system where this case has gone through. What is the core function of the artificial person with our name created by the birth registration and certificate in Canada in the view of the government? What is the core purpose? Why did they create that artificial person? To be subject to their laws? To enslave the man or woman? And above all else, to pay taxes. To pay taxes. That's what they need us for. Per Corey J., Justice Corey, another opinion, the test put forward by Wilson J., Justice Wilson, for determining whether entities are not self-evidently part of the legislative, executive, or administrative branches of government are nonetheless part of a government to which the charter applies were agreed with. So too were her findings that universities do form part of government for the purposes of Section 32 of the Charter. So this Justice Wilson applied her test and found that yes, the government, for the purposes of Section 32, that universities were part of the government. Per Wilson J., this is dissenting. Under Section 32, the Charter applies to legislation broadly defined and to acts of the executive or administrative branch of government. It does not apply to private litigation divorced from any connection to government. Exactly, it doesn't. The Charter doesn't apply to McDonald's, for example. The government-private action distinction may be difficult to make in some circumstances, but the text of the Charter must be respected. The Charter was not intended to alternate route to human rights legislation for the resolution of allegations of private discrimination. Once again, tort. If someone does you harm, you can hold them accountable and liable through tort or common law. It applies to men and women and private actions. The concept of government, purely restrictive of the people's freedom, is not valid in Canada. Government has also played a beneficent role. Freedom is not coextensive with the absence of government. I would argue that point. Rather, freedom has often required the intervention and protection of government against private action. Now, I do agree that government does play a beneficial role. I'm not against government. I'm against illegal and unlawful government. Government for the people, by the people? Absolutely. Governments never give what they have not already taken away. They just use trickery. This party will take away some freedoms or impose new taxes. The next party will come in and reduce those taxes a little bit or give maybe a smidgen of those freedoms back. But they were already taken away. These legal opinions and decisions are example of what the judges believe and what they follow. They believe that the government is fantastic. After all, judges are appointed by governments. They're not elected by the people for the people. It's very important that people understand this, especially, like I said, I don't encourage you to go challenge all of this in court unless you have studied for years. This system of control and this legal system was created for them by them to protect them from us, the people. Oops. Moving right along. A concept of minimal state intervention should not be relied on to justify a restrictive interpretation of government or government action. And once again, ladies and gentlemen, I'm using the term government, which we all know is the Crown Corporation of Canada, a de facto government, a corporation, or the Crown Service Corporation of Canada, if you prefer. But we're reviewing case law, and judges and courts don't refer to the Government of Canada as the Crown Service Corporation of Canada. They refer to it as the Government of Canada, even though they know it's de facto. So, that being said, I use the word government a lot, but it is the Crown Service Corporation of Canada. Government today must assume many different roles vis-a-vis its citizens, and some of these cannot be best effected directly by the apparatus of government itself. Form, therefore, should not be placed ahead of substance. The charter should not be circumvented by the simple expedient of creating a separate entity and having it perform the role. The nature of the government, of the relationship between that entity and the government, must be examined in order to decide whether it acts truly is government, which is acting. The following questions should be asked about entities that are not self-evidently part of the legislative, executive, or administrative branches of government in order to determine if they are subject to the charter. And, by default, all other laws, Acts Statutes, regulations, codes, bylaws, rules of the court, rules of civil procedure. Number 1. Does the legislative, executive, or administrative branch of government exercise general control over the entity in question? Number 2. Does the entity perform a traditional government function or a function in which more modern times is recognized as a responsibility of the state. Number 3, is the entity one that acts pursuant to statutory authority specifically granted to it to enable it to further an objective that government seeks to promote in the broader public interest? So this is the test that was referred to just previously. Ask these questions regarding the artificial person created by the government through the birth registration and applying for the birth certificate and social insurance number. Does the government not control almost all aspects of life through Acts, statutes, regulations, codes, bylaws, court rules, rules of civil procedure? We have to apply to get married. We have to apply for a license to go fishing. These are implementing government policies. Are filing and paying taxes duties of a man or a woman or of an artificial person? Are taxes not imposed duties that we're implementing through the Income Tax Act? Is that not forwarding a broader public interest that the government seeks to promote? After all, without our tax dollars, they couldn't exist. Number 3, the artificial person was created by government with granted rights and imposed duties, one of which is income tax. The biggest is income tax, which, once again, the government claims is in the best for public interest. It seems pretty clear that if we apply this test that has been recognized and accepted in the Supreme Court of Canada to the artificial person, that we are members of government, that we are agents of the government that are implementing government policies. The Highway Traffic Act, the Firearms Act, the Income Tax Act. So that's a very, very important test, but we'll go on. Each test identifies aspects of government in its contemporary context. An affirmative answer to one or more of these questions would be a strong indicator, but no more than the entity forms part of government. The parties can explain why the body in question is not part of government. Or in the case of a negative answer, why some other feature of the entity not touched upon by the questions listed makes it part of government. So they're saying if you answer yes to one or more of those 3 questions, it's a very strong indicator. However, the party is able to argue why it's not. There is a big key for us. The test indicates that we're part of government. Our artificial person is part of government. But, once again, from the Supreme Court of Canada, it's a strong indicator, and the entities can explain why we're not. Why we're not? Because of deliberate deception and fraud.